giving you kind of cafeteria choice.
Yes, sir.
Mr. Chairman, members of the committee, we know that in common reference, hate crime is an offense against a person or property motivated in part by offenders of bias against race, religion, disability, sexual orientation, ethnicity, gender, or gender identity. Now, that's what's known in general language. But in the Virginia Code, the hate crime bill, which I introduced a long, long time ago, is much more narrow in its application. What I would ask us to do today is to take a look at how it might be that the hate crime bill in Virginia could be brought into conformity with what is socially and generally accepted in the community as being those distinguishing features of people against which hate crime is now directed. Mr. Chairman, if it be your pleasure, what I'd like to do, if we could, would be to have two witnesses to come in and talk about the hate crime issue broadly, and then take a look specifically at the bills, if that would be your pleasure.
That would be wonderful, and I appreciate that. So anybody wishing to testify generally about these issues, we would welcome their testimony.
Great, thank you.
Whenever you're ready, Kelly.
So I'd like to call on Mohammed Gula, who is Executive Director of a group called MAGE. It's a Empowering Engaged Muslims, and if he could come forward and offer some testimony.
Good morning. Thank you for inviting me to speak. My name is Mohammed Gula. I am the Executive Director of Engage, the chapter in Virginia. I'm more of a data person, and so a lot of the data that we kind of work with is specifically relevant to the Muslim community. So I'm going to start off with the data in which we have in regards to reporting and the reporting that's voluntary. That's kind of nationwide based on FBI reported that hate crimes jumped in 2015 by 67% against Muslims, and then rose to 20% in 2016. However, in our minds, the FBI hate crime data is unreliable. And the reason why we say that is because in 2015, 89% of lawmakers did not actually report or reported zero hate crimes in their states. So if we look at between 2014 and 2016, according to FBI reported data, hate crimes only rose from 87% within those 2 years. According to CARE, from 2014 to 2016, hate crimes targeting Muslims rose 584%. Most importantly, this hate and this fear has trickled down to our schools, directly impacting our children. According to the Crisis Text Line, a major crisis counseling organization that caters to youth and teens, reported a 600% increase in intakes involving Muslim youth in October of 2016, and then a 900% increase immediately following the November election. And that's specifically in regards to data. Now, when we talk about the penalty of hate crimes, in our minds and in our experiences, as we kind of went through a lot of what we pushed for in the federal sense with House Resolution 257 and Senate Resolution 118, we wanted to make sure that hate crime laws are not looked at as double penalties. It's more so something that is an enhancement statute to penalties that are already considered a crime. In our minds, a crime is not just a crime. Hate crime laws address the repercussions after the fact. The impact of a hate crime is far greater than the already terrible impact on the individual, and it focuses more so on the intent and the motive of that crime. Thank you.
Thank you, sir. Anyone else? Or Delegate Plum, did you want to introduce anyone?
One other witness, I think.
Mr. Chair, committee members, Jennifer Allen, Planned Parenthood Advocates of Virginia. No one should be targeted because of who they are. We strongly support this bill.
Thank you.
I think, Mr. Chairman, the thing to do might be to, with your pleasure, would
showed there's been an 86% increase in murders of LGBT people from 2016 to 2017. Hate crimes against gay and trans individuals are the third most frequent kind in America, and Virginia is not immune to that. We support this bill. Thank you.
Thank you very much.
Hi, my name is Jubeya Masroor. I'm an Islamic school teacher at a Muslim school over here in Richmond, and I teach art. And when there are a lot of things, especially when teachers, I was not supposed to speak first of all when I came here as article, and I have to speak up for that because when they're doing their work, sometimes they open up, and I hear them say things which they shouldn't be talking about, that you're a terrorist, or they pull the hijab, or you're not welcomed here. And I've heard those, and I have to talk to them about that, that it's not, most of people are not like that, but they are being discriminated. And after, lately it's been happening more. And in the Muslim community in RVA, I've heard a lot of middle school kids who say that if they go to the fountain, people talk to them, like say, you terrorist, or go back in the line. So it's been happening a lot even over here. So I definitely support this bill, strongly support this.
Which bill are you?
That's my HB 718.
Okay.
Thank you.
Very much. Ma'am, are you, by the way, are you aware that the existing law already covers
Yes, I
religious
do, but still.
persecution? Okay, thank you very much.
Good afternoon. My name is Gail Dady. I'm the Women's Rights Advocacy Council at the ACLU of Virginia. We support this bill.
Okay, thank you.
Hello, my name is Omar El Gaddafi, and I came here concerned for this bill, 719, HB 1032, and also 266, which the delegate agreed to give us a pass by on 266 due to some of the concerns that were raised. And I've been speaking with Delegate Corey about some of the concerns we had about HB 10 that I'll speak about right now. Specifically, in the reporting part of the statute that's being changed, where we noticed that there was ethnic origin was being removed and was being replaced with national origin, and that's occurring in each of these bills. Although, that's not the intent of the bills, that seems to be a byproduct of them. And, a lot of the people who supported the bill and were against the opposition that me and other community members raised, they said, well, it still has the protections for race. And we feel like, race is more of a codified classification and not really, it doesn't really speak to the face of hate in the Commonwealth or in the country. For example, the woman, the young girl, 17 years old, neighbor Hassanin in Fairfax County last year, she was murdered by the man with the baseball bat as she was wearing her hijab outside of her mosque. And he didn't necessarily, he was not charged with a hate crime because he didn't necessarily know what her religion was, and everyone who wears their hair covered is not a Muslim. There's other faiths that also cover their hair. And when we remove ethnic origin, we're removing the protections for people that are part of a social grouping with a unified cultural tradition, which is what ethnicity is. So, he didn't really know her national origin or sexual orientation or gender or any of that, in order to have committed that crime against her. So right now in the statute, there are no protections for ethnicity in any of the criminal statutes. It's only there for civil action, and it's there for reporting. And each of these bills that's before us that are related to hate crimes is removing the ethnic origin from the reporting. So I feel that while we're adding, I would love to support all of these bills, but I feel that while we're being more inclusive towards gender-based and sexual orientation-based and national origin-based, we can also be more inclusive of ethnic origin-based crimes. Because me as a so-called African-American, I really don't know what my historical background is. I don't know what my lineage is. I can South American, I could be, you understand?
I have no
so-
idea what mine is either. I mean, as long as we're,
Right,
same problem.
right, exactly. So, I think that if we really want to address what the face of hate looks like in our Commonwealth and the United States, then we should be pushing to address ethnic origin-based crimes. Thank you.
Thank you, sir. Okay. Delegate, I think since we just took a bunch of general testimony in favor, we'll take some general testimony in opposition. And we're just gonna, you've set us up to do it this way, so we're just gonna keep going.
Eddie Hale, Virginia, Assembly of Independent Baptists. The Baptists understand in the colonial era what it meant to be persecuted. They were persecuted hugely in Virginia because they were Baptist and didn't conform with the Anglican views. I feel for the comments that have been made, but we have always taken the position that I don't think you can hardly find a crime that doesn't originate in hate. And so our concern is something that was mentioned. Are we creating a double penalty for these types of crimes? I would prefer not to call any of these hate crimes. I would prefer to put the proper penalty within the criminal code where it belongs and treat everyone equitably. Although I understand there are those who look through different lenses, but I feel like that we are missing the point on trying to treat equitably everyone who gets accosted for whatever reason. And who knows that some of these crimes, while they say they were because of their ethnicity or their gender, how do we know it wasn't just a matter of interpersonal disagreements that arose to the level that it did? Thank you.
Thank you, Mr. Chair, members of the committee. Bill Janis here on behalf of the Family Foundation of Virginia. We oppose all of these hate crime bills, both 718, 719 in general, because one of the core principles of the Family Foundation is constitutional governance and limited government. We believe that the role of government should be prescribed and limited based on the Constitution of Virginia and the Constitution of the United States. When you look at these bills, they reach beyond the normal criminal code sections to not just inquire into the criminal act and the criminal intent of the accused defendant, but reach beyond that to the status of the victims and create protected statuses of individuals and purport to create a separate offense and sometimes enhanced penalty based on perceived animus or presumed animus against particular protected classes. In specifically, 718 and 719 have problems. 718 creates novel classes of so we oppose hate crimes in general, but what's particularly offensive, we think, in 718 is it creates novel classes and novel undefined classes in the Code of Virginia who now will be afforded this same kind of protected status on the premise that they are, that the motive of the defendant was animus towards this group. And there are groups like gender identity, sexual orientation, which are undefined in this section, and as far as I know, undefined in the code to date. At 719, it also adds immigration status, right? So you're now looking at a crime that doesn't, an inquiry that doesn't simply focus on the mens rea and the actus reus, but now goes beyond it to sort of look at the status of the individuals. For these reasons, and in general, because we oppose hate crimes, we oppose both 718 and 719. We'll ask you to vote against.
Thank you, sir. Delegate Plum.
Well, Mr. Chairman, members of the committee, I think the opposition has correctly identified what the bill is intended to do. It's intended to reflect the fact that crimes against some individuals because of their gender, because of their sexual orientation and so on, that those crimes are not intended simply to affect the victim, but to affect the broader class of folks. Those crimes that are, for example, against immigration status was mentioned, the intent is not simply to harm an individual, the intent is to send a signal to a class of people. And that, to me, is a separate offense and one that ought to be dealt with, as we did with the original adoption of a hate crime bill. And hate crimes, not new concept, broadly represented throughout the country, and one that I think Virginia should have as inclusive as we can in terms of classes of people for whom crimes now are directed express purpose of bringing fear and concern on the part of that broader class of people.
So what should be the standard then by which we expand these crimes in the code? Reflecting, as you said something about reflecting changing societal norms or what, I don't know how you phrased it. But.
Yeah. Well, Mr. Chairman, when the bill was originally introduced, there was a recognition of the fact that crimes were directed against individuals in certain classifications based on that individual's classification in order to send a broader signal to other people. As society has evolved and as we become more concerned, for example, about sexual orientation issues, it seems to me to be appropriate that we would add that into this as part of the standard. So that it does become an evolving, not unlike the law generally, it becomes an evolving standard based on how the community at large perceives these people and their standing in the community.
Okay. Thank you. Any questions for the patron on House Bill 718? So those of us who practice criminal law call this motive. Motive is not an element of any crime that has to be proven except for these types of criminal acts. I know that your bill goes beyond criminal acts. Everybody up here is against violence. Everybody up here is against being uncivil and being rude and not to each other. We're okay with that. But generally speaking, in society, we're against those things. And those of us who have sat on the subcommittee historically have thought that saying that hurting somebody is a crime and you can go to jail or prison for that for a long time is certainly sufficient without having to pick and choose who might be a preferred class. Those of us who see the emerging societal changes going on our college campuses certainly think that there's a significant amount of hate being directed at conservatives in the world. Golly, we could just keep adding people who are the subject of hate in the world. And that we got too far into it in this room, we could find a little hate for us too. But anyway, we have very sound and solid laws and punishments that some of us up here work very hard to not only attain but protect and make sure that people are appropriately punished when they hurt people and give a broad range of discretion to judges to effectively deal with people when they harm others in whatever way. So that's my 2 cents. Anybody else on the committee?
Sure. So, been here 16 years, prosecutor for 5 before that, so for 21 years, and worked to make sure that when people do commit crimes, there are penalties available for them of up to a year of jail, and then they go. Not conversation, not counseling, not probation, but actually taking punishments appropriate for that crime. And so if any of the speakers were the victims of an assault battery, I hope you're prosecuted. And I hope that through the criminal justice system, the person that did it went to jail. Jail. Not, again, not a conversation, not right, none of that. It's punishment. You did something awful, you should go to jail. We have had this issue come up. This is your first time before us. This is an annual, semi-annual conversation we have. And traditionally, certainly my 16 years, I'm not aware of it passing. And it's for the reasons the chairman described about carving out special classes. I think if I punch Mr. Klein, that's a crime. It's a bad crime. There's lots of reasons I might punch Mr. Klein, but I should be punished for that. I should go to jail. And I don't think he needs to be in a particular class to take access to the criminal justice system. So with that, Mr. Chair, I would like to make a motion. Mr. Chairman, I would move to PBI House Bill 719.
Motion is to PBI. Is there a second? Okay. Any further discussion? You have 2 minutes. Delegate Plum, if you wish to close.
Yeah, Mr. Chairman, I appreciate your comments. We've had this discussion for several years now, and I do recognize that the code deals with people who commit crimes in an adequate way that we make sure that that happens. It seems to me, though, that there's crimes and there are crimes, and I'm talking about a crime beyond, for example, a simple assault and battery that might be intended to not simply hurt the victim, but rather to send a message to the broader community. And that's what that second level of punishment is about. You can't go around and beat up on people and try to send a signal to the broader community that because of your religion, your ethnicity, whatever the cause might be, that you can do that and get by with it without a recognition in the law that that needs punishment and recognition as well. Again, our discussion continues on this. I respect where you're coming from in terms of the adequacy of our law. It seems to me, though, that there are people who get picked on, and there are people who are victims of crime because of who they are, the class of people that they are, and we ought to recognize that in the law.
All right, any further discussion? Okay. All right, close the roll. That bill is PBI. Delegate Plum.
And Mr. Chairman, the discussion would be the same on the next two bills, I believe, even though the second bill creates, I know, an additional concern on your part because we deal with immigration status, which may not at the time be defined in the laws. I have nothing additional to add.
Those are all. Mr. Chair, I don't want to cut any debate or there's other public comment. The representative will make a motion. Go to bill. Mr. Chair, for the previously discussed reasons, I move PBI House Bill 719.
Second. PBI and a second. Any discussion?
Mr. Chairman, if you look at the data, as the gentleman earlier mentioned, there's no denying the fact that there's an attitude now towards immigrants in our community that we as a community ought to respond to. And that response, in my estimation, ought to be that if you commit a crime against an individual because of that person's status in terms of immigration, that there ought to be some additional punishment for that.
All right, the motion is to PBI. Any further discussion? Please cast your vote. Close the roll. Delegate Plum.
At House Bill 720. House Bill 720 prohibits persons convicted of simple assault or assault battery when the victim was selected because of his race, religious conviction, color, or national origin from purchasing and transporting a firearm for 5 years following such conviction. If you look at how these hate crimes are committed, guns are often a part of that. And this suggests that if you're going to buy a gun for the purpose of intimidating other people in your community, then that ought to be an offense.
It would already be an offense or several offenses to use a gun for various crimes, right? Counsel?
Mr. Chairman, there are several offenses. This bill is attempting to criminalize the after you've been convicted of a assault and battery or a felony assault and battery dealing with hate crimes, to criminalize the purchase and transportation, not possession, of a firearm. And it is, so it doesn't, it's akin to the protective order violation, prohibition against firearms. So it's the purchase and transport, but it's the after you've been convicted, not the use of it during crimes.
Just clarifying what was said there. Delegate Clark.
Just a follow-up question on that, Mr. Chairman. So if the underlying crime had nothing to do with firearm, it would still affect your ability to purchase a firearm? Does that mean what the bill would do?
Mr. Chairman, Delegate Klein, yes, if the underlying crime was that misdemeanor assault, hate crime assault or battery, then that would criminalize or keep you from being able to purchase or transport a firearm for the next 5 years, even if the firearm had nothing to do with the original crime.
Mr. Chairman, speaking of the bill, I see that it says simple assault or assault and battery, and it's, the lawyers up here know assault is a fist drawn back in close proximity, and the linking of that, or any kind of assault and battery without a weapon to one's ability to purchase a weapon seems kind of a stretch. So, when it's appropriate, Mr. Chairman, I'll have a motion.
So, am I correct that this bill doesn't even purport to take your gun rights away if you got convicted of brandishing a
That's correct, Mr. Chairman.
All right, thank you. Delegate Klein. Mr. Chairman, I move the PBI. There's a motion to PBI. Is there a second? Delegate Herring.
Speaking to the bill. I just want to remind everybody, I'm sure you are aware, but that this is in conjunction with a hate crime, so it is pulling your FISBA Act. But it's also, you're doing it because of race, religious conviction, color, national origin. So there's a propensity toward violence and based on someone's makeup. And so I think it's a very fine bill, and I look forward to supporting it. And I support other students.
Delegate Paul.
Mr. Chairman, my analogy would be to say that and I know that talking about background checks may not be a popular subject here, but if you look at background check and someone's committed a felony, whatever that felony may be about, came back a firearm. So here, if you, as the delegate says, you have necessity towards hateful actions, just as would be the case with someone who had a protective order, the action would be, I think the community's action would be to be able to deny that person access to a firearm.
Okay, the motion is to PBI. Please cast your vote. That bill is PBI. Thank you, Delegate Paul.
Thank you, sir.
Do you have another, or is that all? That's all you had?
That's all. That's all for today, sir.
Okay, yeah, I understand. We got to keep letting you go first. Quit letting you go first, because it just doesn't treat properly. Delegate Sullivan.
Thank you, Mr. Chairman. Good afternoon, members of the committee. It's actually a good segue, Mr. Chairman. My HB 32 also deals with a couple of or part of of Delegate Plum's HB 718, but a specific part of it. And your rejection of his bill, I'm not sure, since it was a larger bill, necessarily applies to mine, so I appreciate the committee's time. HB 32 is focused only on section 52-8.5 of the code, which has to do with reporting hate crimes, specifically how our law enforcement agencies report hate crimes. It does not try to create any new hate crimes. It's not an effort to condone any lifestyle choice. It simply is a law enforcement provision. And so I would suggest to the committee that if we were dealing with any other portion of the code, it might be a little less controversial than it might become this morning. What this does, what HB 32 does, is simply codify into statute what our state police are already doing. And they're here to testify, and I believe they'll confirm that for the members of the committee. What happens is the state police gather information from all of the other local law enforcement agencies in the Commonwealth, which goes to something called the State Fusion Center, which is Virginia's intelligence gathering center. The Fusion Center then uses that data to identify trends and aid law enforcement statewide with respect to what might be going on, where we might need to divert resources to deal with ongoing situations that might have to do with hate crimes. More relevant to this particular bill, Mr. Chairman, is that the Fusion Center then sends all of our data, the state data that gathered from all the places around the Commonwealth, to the FBI database. And that ends up in the Justice Department's Bureau of Justice Statistics, the National Crime Victimization Survey, and the FBI's Uniform Crime Reporting with regard to hate crime statistics. So this document, all this information gets sent off to the FBI. Now, what the data shows, and I assume everyone on the committee knows this, is that unfortunately over the last 4 years it's been pretty consistent that between something like 15 and 20% of hate crimes in Virginia have been based on sexual orientation. The most recent statistics were 2016, and 18% of the hate crimes reported to the FBI by Virginia State Police were related to sexual orientation. If we give the raw it's 22 crimes out of 122 total reported hate crimes that the FBI database shows for Virginia. Just last week, there was a conviction in Richmond Federal Court of a gentleman, shouldn't call him a gentleman, a guy named Hill, who was convicted of assaulting a coworker at a local Amazon facility, assaulting him because of his sexual orientation, and he commented that people who are gay should expect to be assaulted. That'll no doubt become, under their obligations, the state police will report that when it comes time to report 2018 data to the FBI database, a sexual orientation related hate crime. Now, if you look at what HB 32 attempts to do, it simply adds to the statute the words with respect to what the state police should both require of local jurisdictions, that is, I'm on line 15, it's paragraph B of the bill. State, county, municipal law enforcement shall report to the department, and then C talks about what hate crime means. It simply adds the words sexual orientation, gender identification, and I have it drafted as national, but you've heard some discussion this morning about how the word ethnic should in fact stay in there, and I believe the state police actually have brought, council may even have it, a change that we could do here as a line amendment. So what I'm here to tell the committee is that the state police have for years been reporting to the FBI hate crimes related to sexual orientation, hate crimes related, and will soon be reporting, starting this fall, hate crimes relating to gender identification, because that's what fits the FBI database and what is required by the FBI database. So all HB 32 does is A, conform our reporting with what we're already doing, and B, conform it with what the FBI statistics require of us.
Questions for the patron? Did you have anybody wanted to testify specifically about this bill?
I believe the state police did want to talk about the ethnic and national.
They're going to confirm everything you just said, right? Yes. Okay. Do you need to add anything? You're welcome to. I'm just, we'll take your word for it that I'm looking at it right now, that they are.
I appreciate that.
Yes, sir. Delegate Bell.
Sir, state police.
Sorry, come on.
I have a question that Delegate Sullivan may know the answer to, but I'm not trying to, actually, I'm curious. So, I'm looking at some data from a couple of years ago that they sent to me for lots of commissions and committees I'm on. So there are 4,593 assaults in whatever year this was. The last couple of years, I can't see it. I was a prosecutor, it was a long time ago. How do they, when something is not, how do they know the motive? I mean, does the prosecutor each day come back and say, well, over the course of delivering the evidence?
Is it the police report? There's a box to check?
Yes, there's going to be an indication with regards to if it falls into one of the reportable categories.
He's wondering who reports the category and in what form, at what point in the process of
Is the prosecutor, is the line officer, did the state police go through afterwards?
It's going to be police reporting. It's going to be uniform crime data, and that goes to the nature of the amendment that we seek to include ethnic, because ethnic is one of the legacy categories under UCR that the FBI requires, so that we can transmit that information properly to the FBI. So the ethnic is going to be the category by which it signifies that it's a hate crime, or one of the potential ways that it can be signaled.
You're answering a much more important and deep question than I was asking. I suspect I'm just, is it
Yeah, I'm not.
the officer, when he does it and fills out the summons, is it somewhere in the police report?
It's
You
gonna
all
be a
go through
police
afterwards and review? Does the prosecutor check a box in the course of the trial? I mean, most of these cases, as you know, there's no great big police file. It's, I mean, if there is any, it's whatever is jotted, it's a misdemeanor. It's jotted down at the time, and we get to court, we try to figure out what happened.
My understanding that it would be the police report that would create that information.
Delegate Mullen?
Thank you.
Mr. Chair, just answering the Uber Chair's question
we're just talking about a regular assault and battery. How did you figure out that it
We
was?
were talking about that like on the P3s or also just puts on the name and the address.
It depends on what you mean. What's a P3?
It's the form that's submitted to the check to indicate the race.
I don't know. That's what we're trying to figure out.
Okay.
I'm
Mr. Chairman,
yes, sir.
never been a prosecutor.
You made better choices. You made better financial choices.
I don't know about that. I don't know about that. Obviously, I would defer to the prosecutors in the room and, of course, to the state police. The point I want to make is this is already happening. I'm not trying to change the way that decision's made, who makes it.
I understand. But Delegate Bell was curious
Fair
about
enough,
that.
fair enough. Sometimes it may be the admission of the defendant, as in the case of the fellow.
It's actually, there's a reason I was asking was when there's
that
an element,
information ends up on his.
Yeah, I get it.
when there's an element of defense at the end of that case, we've been on reasonable doubt after hearing both sides, someone has decided that you did steal more than $200 or you did commit something as an element of offense. These are not elements of defense. So at some point, someone is making a determination that is not later confirmed by the court about what happened. I was just trying to
Sure.
hear, I mean,
I agree. I point out that the prosecution I talked about was actually a federal prosecution, in which I think that probably is an element of the offense.
Oh,
So
sure.
in that case,
Stand for
you're
saying-
prosecuted for a hate crime in federal court.
Delegate Collins.
I have a question for state police, kind of on the same lines. So you were dispatched to a football field where a green person has beaten up a blue person. And when the police officer does the investigation, it's because his son knocked the other son down on the field. That is not considered a hate crime, correct?
Mr. Chairman, no, Delegate Collins, based on those facts, no.
Okay, my question is, I'm sorry, I'm going to drill down my question, because on the police report itself, you're going to be checking the ethnicity of the victim and the suspect on the police report, right?
Correct.
Okay, is that the data that you guys collect and then send off, or do you wait for an actual conviction before you send the data off?
That data would be collected on the police report, and that would be the basis for the uniform crime.
Okay, so on the uniform, and I'm just asking the process, having done this, just want to make sure that I recall from doing it 20 years ago. So it would indicate to the FBI that there was a blue on green issue. Is that?
That's correct.
That goes in the database?
Yes.
Okay, so it's not necessarily a hate crime per se. It's just simply, here's some data for you to add to your overall hard drive.
That's my understanding.
Thank you.
Delegate Aaron, did you just?
I think I got my question answered, thank you.
Delegate Bell.
Mr. Chair, we had a nice discussion by, I thought, of several witnesses and a couple of delegates with thoughts on this issue remain as they were before. I'd like to increase with the creation of special class. I understand the state's already happening. I'm not in a position to impact that. I'm not trying to change anything. Mr. Bill would do something for the code of Virginia, so I would move to PBI.
Motion to PBI, is there a second? All right, any further discussion? You have 2 minutes if nobody else chooses to.
I appreciate the delegate's position. I would respectfully disagree. I'm not trying to change the law of Virginia. This is the statute by which the General Assembly directs its law enforcement agencies to gather data. And right now, it doesn't reflect what we do. And I'm simply trying to make sure that the code reflects, in fact, what's happening in the real world and what our own law enforcement is doing and what the federal authorities are expecting us to do. As of now, it's happening simply, I guess, out of the sense of duty or something of the Virginia State Police. But this is where the General Assembly speaks as to what data we should be collecting and announcing to the world is happening in Virginia. And it's inconsistent with what's happening in the real world, and we ought to fix it.
Thank you, sir. The motion is to PBI. Please cast your vote. All right. Close the vote. It is PBI.
Thank you for your time, Mr. Chairman and members of the committee.
Thank you. Delegate Bagby.
expect me to come today, and I wish you would have allowed me to bring this bill up, House Bill 833, prior to you passing your 1015. But I thank you all for passing 1015, which makes my bill, to my understanding, unnecessary.
Does it do that? Is that 100%?
The only difference, Mr. Chairman, is that under Delegate Bagby's bill, subsection A, which is the misdemeanor hate crime, is not included in your bill 1015. It would include the felony hate crime, and it would include the felony unlawful entry crime for and all the rioting activities.
Mr. Chairman, and it would cover everything that is in Article 5, which are crimes, activities offending to cause violence, which are your clandestine organizations, wearing masks, prospering, those crimes would all be covered because those are all felonies.
Rioting.
Rioting is not in the article being added by Delegate Bagby's bill. I believe it's already in the multi-group grand jury list.
So we're doing 90% of what Delegate Bagby.
99.
Okay. Okay.
Well, you're missing felony investigators.
So this is the point of the meeting where I'm just struck by the fact that persons of a certain ideological bent, this is the day that they want to help us hold people accountable for committing crimes. And for that, we appreciate them being here today to help us do that. That is what we do in this subcommittee year in, year out, is hold people accountable for their crimes, make sure they're adequately punished for their crimes, make sure they are not just simply forgiven by society and released from prison early for having committed their crimes. So we try to do that in a way that doesn't single out particular crimes or particular identity classes or whatever. We just want people to, as Delegate Bell said earlier, be accountable for the crimes they commit. And so,
Yes, Mr. Chair.
yes, sir, I'm sorry to use you
want to
as
say
my.
thank you.
Okay.
And you simply say, well,
I know.
You were using it.
But he's smiling, and I feel like I can say this to him at this point. So maybe not. Anyway, thank you.
Thank you.
And so, how would you prefer to handle your bill in that sense then? Would
I'm
you-
comfortable with just striking the bill.
And you want to sign on as a co-patron to the other bill, perhaps that
A Chico patron.
done because of what I just did to you. Right. Okay. All right.
Thank you.
Co-patron. Thank you. Yes,
Chair,
sir.
the request of the patron of the strike.
All right. There's a motion to strike. Please cast your vote. Close the vote. Delegate Boyska, I'm sorry, now we have one more thing I want to do first before we get into that. What, Delegate, who has? Delegate Watts, did you have one in the same vein, or, okay, please, let's do that then. Sure.
Thank you, Mr. Chairman. House Bill 300. I guess let me start with the how this bill differs from the bills we've heard thus far. It does not make any change to the what I'm going to call the traditional list of race, religious conviction, etc. So I'm not adding any words there. Now let me speak to the origin of this bill. The origin of this bill grew out of a incident of racial epithets being spray painted on the local Jewish community center and on a nearby Church of Christ, long-standing church that had a welcoming sign. And constituents were very concerned about what the punishment would be for this kind of, and I believe they included swastikas. And looking at the code, I was taken by, struck by the fact that I could assure them that such actions as far as damage to property, would be raised to a felony out of a hate crime, clear identification. But when I looked at the statute before you of 15.257, it is at best described as confusing as to whether or not someone who, and forgive me as the non-attorney, who assaults someone with hateful language, threatening language, and are close enough to the person that they could carry it out, as to whether or not that would be raised to a felony, as it would in subsection C if I were talking to a judge or a policeman, etc. So what House Bill 300 does is attempts to clarify this, putting the assault and battery of someone as a hate crime under the same posture that it is if you had damage to property or if it were against a law enforcement official, or the other long list that has been added.
Mr. Chairman, what this bill does is it removes the misdemeanor crime of hate crime. It makes all actions that are motivated by race, religion, etc. a felony. No matter whether there was bodily contact made, whether there was any bodily injury, and so it becomes a Class 6 felony with a mandatory minimum sentence of 30 days if you raise your fist at somebody but not strike them what somebody deems as a matter of hate. The example that David Watts gave would have been a felony no matter what under 18.2.137, because that's the damage to property statute. That doesn't have a hate crime clause in it. It's a Class 6 felony based on the value of the damage alone. And so the change that this bill makes is it doesn't require any bodily injury to make a felony charge. In fact, it doesn't require any actual contact with somebody to make a felony charge.
What's the difference between A and B under current law?
Mr. Chairman, under current law, Section A requires an assault, and it requires it to be motivated by hate for race, religion. Section B requires a bodily injury, and so.
Mr. Chair, Bill, you go. In A, I get the no injury assault. If council could help us, what would be the racially motivated physical assault? I'm trying to think of one of those cases that wouldn't be ready, depending on fact pattern, or it wouldn't be malicious wounding of some sort.
Mr. Chairman, Delegate,
That would result in bodily injury. No, I'm sorry, I'm taking it the other way, which would be the conduct that people in this room, people listening would be saying that's something where someone should go to prison, not jail.
Mr. Chairman,
Under this
Delegate,
section.
I agree with Delegate Bell. Under Section B, I cannot think of a time where if you actually commit a bodily injury, that it wouldn't fall under malicious wounding if it was motivated by hate for race, religion, etc. Malicious wounding is defined as the causing of bodily injury, at least one of the definitions, causing bodily injury with malice. Malice is the doing an unlawful act without justification. So if you are motivated by hate, you are clearly doing an act with malice, and if you cause a bodily injury, you're getting all of the elements of a malicious wounding, which malicious woundings punishment is 5 to 20, which is higher than a Class 6 felony.
Mr. Chair, I'm going to ask that, I think, and that would be available. In other words, there's nothing precluding a prosecution along those lines if someone did this for some motivation that you're going to describe. We're just not creating a special subset for certain motivations.
Malicious wounding would always be available in order to prosecute the case in which somebody is actually injured. And bodily injury is a very low burden. It's just some sort of bodily harm. That would be available for use. I think there really wouldn't be a time where subsection B applied and malicious wounding did not.
as I'm following this line of questioning, I believe that subsection C reflects exactly the questions being asked about the structure of this. Subsection C does not contain bodily injury, which is why I have stricken it in subsection B as something that is again, not parallel, trying to bring this all into the same structure, despite the history of the drafting that may have led to it originally.
Would you mind yielding for some additional expertise there right behind you? Would you move aside for a second and let Mr. Doucette? There, that's what I'm after. Thank you.
Mr. Chair, Mike Doucette, former Commonwealth Strike at the City of Lynchburg, Executive Director of the Virginia Association of Commonwealth Attorneys. There is an additional element to malicious wounding other than bodily injury, and that's a specific intent to maim, disfigure, or kill. And that's why, even if you have it, we have plenty of assaults with bodily injury that we cannot prosecute as malicious woundings because we don't have that specific intent to maim, disfigure, disable, or kill. And that is an additional element. I'm not speaking on the bill, I just thought that the body should know that there is an additional element.
I mean, it's hurting your ears.
It was.
Can I ask this? Somebody takes a beer bottle and attacks you with it. Those are commonly prosecuted as malicious wounding.
They are but it's not only we have an injury, but we have we can have at least a plausible argument that there was an intent to maim, disfigure, or disable, or kill because of the beer bottle. If it's a fist, and I've had plenty of fists where you punch somebody and they break their jaw. You've got a bodily injury, you've got malice, but you don't have it oftentimes unless you have a disparity in size and training. Someone's a judo expert. We cannot prosecute that as a malicious wounding. We have to prosecute that as a serious assault and battery, but it's a class 1 misdemeanor nonetheless.
Is it not true that the intent, though, can be inferred by the likely and probable consequences of your action? Meaning, I say, I didn't mean to break his jaw, but I had a baseball bat, and one of the animus is listed, and I hit him with it, and it broke his jaw. That would be a malicious wounding case. That wouldn't be a...
With a baseball bat, yes, sir, but if you broke his jaw with a fist, it would not.
No, I understand you were saying fist, but I'm saying all these other things, the ways that people hurt each other. Almost any weapon besides a pillowcase or your fist would be something that would at least arise a malicious wounding charge.
Absolutely.
And if it's assault and battery, it's punishable up to a year based on the combination of various factors the judge considers, including things like this, right?
Yes, and again, I was just stepping up to say that there is an additional element to malicious wounding.
I understand what he's saying there.
Just
so. You already have a job.
That's right. Okay, thank you. Mr. Chair, Kelly Bell. I'm sorry, I feel like we're not there yet. I'm sorry. I have a motion at the appropriate time.
Okay. Anybody want to talk for a little bit? Did you want to say anything else? I'm sorry I made you stand aside there. I just wanted to use
I'll address the motion.
Okay.
I'll move to go.
The motion is, is there a second? Delegate Watts.
Again, I am really regret that this has gotten apparently some baggage, because I regard it as a pure clarification. Again, given the history of this statute, it's very confusing. Yes, I admit, I'm not an attorney, but I can't tell you how many different definitions there are of assault and simple assault when I tried to research it. When I looked at the code and the citations on this particular section, the citations in our code books have 6 pages of court cases along this line. Therefore, again, I urge the body to pass this piece of legislation and clarify the stature of this long-standing recognition of hate crimes, which we have then added to in a totally different look when we're dealing with a long list of officials below in subsection C.
Delegate, you have anything to add? All right, please cast your vote.
Yay.
All right, close the roll. That bill is PBI.
essential right to privacy extends to a woman's right to make her own medical decisions, including the decisions to have an abortion, without interference from politicians. More than 18 months ago, the United States Supreme Court decision in Whole Women's Health v. Hellerstedt held that abortion restrictions are unconstitutional unless the benefits they confer are sufficiently justifying the burdens that they impose. The United States Supreme Court also held that courts must consider credible, reliable evidence when assessing a state's justification for a law restricting abortion access, as well as how the law will impact the real people affected. In contrast, over the past many years here in Virginia, the General Assembly has passed more than 12 medically unnecessary restrictions and proposed over 75 restrictions on a woman's reproductive health care, making it more difficult to obtain an abortion without conferring any health benefits. All of these restrictions work together as a scheme to create a substantial obstacle to a woman seeking to access abortion. Laws that restrict a woman's access to abortion harm the very women they are claiming to help. And these sham laws that have the purpose or effect of shutting down a woman's reproductive health care providers makes it increasingly difficult, sometimes impossible, for a woman who has decided to end her pregnancy to having safe access to legal, high-quality care she needs, which is a recognized right in our country. Virginia laws restricting access to abortion create sharp disparities in access to care that are troublingly reminiscent of the time before Roe v. Wade, when access depended on a woman's economic status, her race, where she lived, or her ability to travel to another state. A woman's ability to access health care, including abortion, should not depend on her income or her address. Comprehensive reproductive health care, including safe legal abortion, is a vital component of a woman's overall health. Virginia women, families, and communities benefit when a woman has access to the full range of comprehensive reproductive health care services, including abortion. We should not be criminalizing women for making these decisions. To recap, my bill removes the code provisions that are unrelated to improving medical health as deemed by Hellerstedt and Whole Women's Health. Leading medical experts and organizations strongly oppose these medically unnecessary restrictions on a woman's health care services. Politicians, not doctors, are pushing these sham restrictions on a woman's ability to access an abortion. We know in this room that a woman knows when she's ready to be able to start a family. Everybody on this dais should not be taking that responsibility. No one can fully know the circumstances a woman faces as she decides to end her pregnancy, and no one else should be able to make that decision for her. A woman is fully capable of making thoughtful decisions about her family, her future, and the health with the advice of a healthcare professional. I stand up for women today to enable them to be able to make these decisions with their healthcare providers without interference from politicians who presume to know better. I have brought along with me Gail Deedy, who is here to answer any questions you may have, and I hope it will be the pleasure of the body and my colleagues to be consistent and oppose the restrictions of people's rights by reporting HB 1231, the Whole Women's Health Act, to the full committee. Thank you so much.
Thank you very much. Don't run off yet. Housekeeping, council. Delegate Fowler, how do you pronounce your first last name? So I don't. Converse. All right. I apologize. I will do that again. Delegate Converse Fowler's bill and Delegate Rodman's bill, are the subject matters of those included in Delegate Boysko's bill? Okay. So here's what I'd like to do then. You have people who want to come testify on your bill. I would like to be respected
Chairman and committee members. My bill speaks to a section that is included in the whole women's health. Of course, we want to make sure that women are respected who are seeking reproductive health care, that no one should encounter judgment and stigma when they go to the doctor. As you know, abortion should not be singled out to be treated differently than other medical procedures. That's why I concentrated on this specific section of the code and included in the other areas. In 2013, for example, the General Assembly repealed the mandatory 30-day waiting period before Virginians could undergo a sterilization procedure, because I know this body recognizes that women and men are able to make their own health care decisions free from political interference. The time is now for the General Assembly to recognize that women are capable of making their own decisions. My bill specifically speaks to the code 18.2-76 and amends it to move any language removing any language about informed consent. This section speaks to non-medically necessary consent requirements that only apply to abortion services. That removes the waiting period, the ultrasound requirement, and the extra special informed requirements that actually exist on top of existing medical care. So as this piece of the code is removed, so would be the penalty. It's not that we don't want to give women informed consent. They have informed consent when they seek out medical procedures. Thank you very much.
Thank you. Delegate Congressman.
Thank you, Chairman and members of the board. My bill provides changes to our current regulations relating to abortion after the second trimester. The reason for the bill is to provide assistance to women who are experiencing health problems due to their pregnancy. As it stands now, a woman is required to have 3 doctors approve an abortion after the second trimester. This bill allows for 1 doctor to approve the procedure when the pregnancy is likely to result in the death of the woman or substantially impair the mental or physical health of the woman. There are no other medical procedures that require the approval of 3 doctors in the Commonwealth of Virginia. Therefore, the law as it stands violates a woman's medical rights by requiring 3 doctors to approve a medical procedure. No other medical procedure in Virginia requires a second or third doctor to sign off before a physician may act in his or her best medical judgment of a consenting patient. Also, consider that in more rural areas, there will not be access to 3 physicians to obtain, there may not be access to 3 physicians to obtain the needed opinions. There is no medical reason for requiring more than 1 doctor to sign off on an abortion. The 2 additional doctors requirements was created by politicians and motivated by politics. It was not informed by doctors or medical evidence. Abortion should be treated like any other medical procedure, and it should not be delayed for political reasons, particularly when a woman's life or health is at stake. Doctors oppose these kind of medically unnecessary laws that place politicians in the way of the doctor's best judgment and their patients. The American College of Obstetricians and Gynecologists has said, laws should not interfere with the ability of a physician to determine appropriate treatment options. Lastly, the 1992 U.S. Court Supreme decision, Planned Parenthood of Southeastern Pennsylvania versus Casey, set a new standard for the regulation of abortion, making restrictions allowable as long as they do not place an undue burden on the woman. This law is in violation of the Supreme Court decision, causing undue burden on the woman to find 3 doctors to approve the procedure. In the matter of health, seconds, minutes, and days are critical. And in the time it takes to get an appointment and get in 3 different doctors could be the matter of life and death, thus violating the Supreme Court regulation. And also, I just want to note the undue burden is having a purpose or effect of placing substantial obstacle in the path of a woman. So what if there's no purpose? So, thank you.
Thank you. Yes, ma'am. All right, any questions for any of the patrons? Any members of the public who wish to speak on any of those bills, please come forward at this time.
Good afternoon. I'm Gail Dady with the ACLU of Virginia. Just wanted to quickly just sort of clarify with respect to the whole women's health, be heller set decision. Clearly, that decision was based on specific facts, and it was based on restrictions in Texas that were passed purportedly because they provided a medical benefit. Clearly, there's a lot of changes in this bill that go beyond that, that are looking generally at destigmatizing abortion, at treating medical providers that choose to provide abortion care in the same manner as other medical providers who perform the same or similar procedures. And this isn't so much about what we have to do in Virginia, it's about what we should do. It's about health policy, it's about women's health, and it's about ensuring that a woman actually has access to her constitutionally protected right to abortion. So the intent of this bill is to repeal and amend abortion restrictions that perpetuate false stereotypes about women and providers that are neither rooted in science nor fact. These restrictions are not just anti-abortion, they're anti-women, they're anti-family, they're anti-minority, they're anti-LGBTQ, and they're anti-healthcare. The whole Women's Health Act is about more than removing unconstitutional abortion restrictions from the books in Virginia. It's about repairing access to abortion care that was decimated by the politically motivated clinic shutdown laws, ultrasound waiting period requirements, and insurance bans implemented between 2011 and 2013. And it's about trusting the Department of Health professions to ensure that all medical providers, including abortion providers, are providing quality care in safe facilities, just as they did before 2011. And it's about ensuring people who decide to have abortions or seek information about terminating a pregnancy are treated with respect and dignity. And it's about ensuring the people who provide abortion care are seen and respected as the medical professionals, the licensed medical professionals that they are, and treated equally under the law. Thank you.
Thank you.
Good afternoon, my name is Tanisha White and I'm reading on behalf of Alex Hillebrand. My name is Alex Hillebrand and I'm a resident of Arlington, a medical student at Georgetown University, and I support HB 450. According to the American Medical Association's Code of Ethics, all patients have the right to make an informed decision about their medical care after a thorough discussion with their physician. These rights extend to Virginians seeking abortion care. The concept of informed consent comes from the basic right all patients have to determine what will be done to their bodies. It does not include biased, state-mandated, non-medical information or unnecessary state-mandated waiting periods or state-mandated imaging in the form of an ultrasound. This bill recognizes medically appropriate counseling does not include government interference. When I'm a physician, the conversations that take place between me and my patients will focus on her medical needs. I will provide all the options to her in a timely, unbiased, non-judgmental manner, and only she will be able to give informed consent to any treatments that we agree are best for her. I ask you to vote yes on HB 450 because as a medical student, I believe my future patients deserve to make decisions about their own health care without interference from the state of Virginia. Thank you.
Thank you. And Mr. Hillebrand. Yes, ma'am.
Hello, my name is Michelle Wooten, and I'm here to read on behalf of Caitlin Looney. Hi, my name is Caitlin Looney, and I'm one of Senator Saxlaw's constituents, and please do support HB 450. Before my abortion, I had to spend the past 5 years believing I would never have children because of medical problems that caused infertility. I had assumed my symptoms were due to my previous medical conditions and the stress transitioning to a new job. Because of the employment transition, I had a gap in coverage and waited to see a doctor until my coverage began. By the time I finally saw a doctor, I was almost 9 weeks pregnant. I knew I wanted to have a medication abortion, but I had only 3 days until that was no longer legally possible. Virginia's restrictions included a mandatory waiting period, left me with no other choice but to travel to another state. The hardest part wasn't getting the abortion. It was figuring out the logistics of getting an appointment to seek the care that I needed. Virginia's informed consent restrictions almost blocked me from exercising my constitutional right to an abortion. Please support HB 450, so others can access quality health care with dignity. Thank you.
Good afternoon, my name is Diego. I'm going to be speaking on behalf of Sarah Flores Shannon. My name is Sarah Flores Shannon, and I have been a leader and an activist with the Virginia Latina Advocacy Network for the past 3 years, and I am here to support HB 1231. I first got involved with the Virginia Latina Advocacy Network because of my passion for expanding access to affordable abortion care. During the summer of 2016, I stood with activists from VA Lawn on the steps of the Supreme Court when the ruling for Whole Woman's Health versus Hellerstedt was declared. It was a joyous moment when the highest court in the land declared that the abortion restrictions in the case placed on the burden on a person's access to abortion. It is past time to remove and prevent medically unnecessary trap laws to stand in the way of abortion access. Too many trap laws disproportionately impact low-income women and women of color. A woman's ability to access health care, including abortion, should not depend on her income or her zip code. Virginia legislators need to trust women and their families. We are capable of deciding if, when, and how we start a family and do not need medically inaccurate and unnecessary laws standing in our way. I urge you to support HB 1231. Thank you.
Good morning, my name is Casey. I'm going to be reading a testimony for Megan Kinkle. Good morning, my name is Megan Kinkle, and my representative is Senator Peterson. I'm a registered nurse specializing in labor and delivery.
Nobody wants to acknowledge their delegate, apparently. It's okay. We'll just keep hearing from whoever the senator is. Go ahead.
I'm a registered nurse specializing in labor and delivery, and I support HB 1231. Our patients rely on medical professionals like me to make the best decisions for themselves. When the government actively, intentionally disrespects the patient-doctor relationship, you put your ability to deliver high-quality care in jeopardy. Informed consent allows the government to intervene in the information and the patient receives, subjecting them to misinformation, judgment, and stigma about a personal private medical decision. Furthermore, requirements like the mandatory waiting period purposefully delay abortion procedures, which can jeopardize a patient's health and safety. A first trimester abortion is extremely safe with a risk of complications of less than 0.5%, but as with many common medical procedures, the longer the procedure is delayed, the more the chance of complication can increase. The medical community does not need the government to interfere with when we can deliver our care, putting both our patients and our ability to provide best practice, high quality care at risk. Please support HB 1231.
My name is Erica. My senator is Senator Sherrill. I'm reading for a case from Arlington. I'm not a lawyer, nor am I a politician.
Now I have to ask.
They did this in the Senate.
Oh, I know that. Who's your delegate?
My delegate is Hala Ayala.
Okay, I was making sure you knew. All right.
I'm going to their town hall meeting tomorrow morning.
Okay, give her that. Okay, thank you.
I'm not a lawyer, nor am I a politician. I felt compelled to speak up due to something that seemed glaringly obvious to me and yet somehow not obvious to some of the General Assembly. Section 7 of the Constitution of Virginia describes the oath every delegate of Virginia has taken for office. It says, I do solemnly swear or affirm that I will support the Constitution of the United States. Considering the U.S. Supreme Court case of Whole Woman's Health versus Hellerstedt ruled that trap laws are unconstitutional, it seems crystal clear that HB 1231 is correcting an egregious, unconstitutional overreach in Virginia. Please bring Virginia into compliance with the United States Constitution and support HB 1231. Thank you.
Good afternoon, committee members. My name is Nicole Grimm. I'm a resident of Alexandria, Virginia. My delegate is Mark Levine, and I am reading on behalf of Kristen Gleikoff from Fairfax, Virginia, whose delegate is not on
I
this
just want to
committee.
be clear, that's not a requirement anymore.
I
I think we started something.
know it's not a requirement.
No, it's fine. Please continue.
I'm an informed
People appreciate the
Virginian.
shout out. Yes, ma'am. Thank you.
Nothing is more devastating than seeing a friend in trouble and being helpless. My friend needed an abortion, but we were both too young to drive and didn't work. I tried selling my clothes, I tried raising money online, but it wasn't enough. When she had no other option but to tell her unsupportive parents, they forced her to drop out of high school. Now I'm in college and she's working on her GED. If more qualified providers could perform abortions, perhaps she could have traveled less expensively to a closer healthcare center. If second trimester abortions weren't limited to hospitals, maybe we could have saved longer. There is no doubt that each of these medically inconsequential regulations each played its part, but not to ensure the well-being of my friend. Please support the Whole Woman's Health Act and the other legislation mentioned here to support women like my friend. Thank you.
My name is Martha Wright. As a wife, mother, grandmother, I support these bills, support to repeal the unnecessary regulations of a waiting period and ultrasound. Thank you.
Hi, my name is Tara Gibson. I'm going to read a story shared by Carrie Mills, who was asking me to support HB 1231. Until I was out of grad school and had insurance through my job, Planned Parenthood was my healthcare provider. I did all of my screenings there. It was great to have a reliable place to go that I could afford. It was a great resource to me as a young adult, no longer on my parents' health insurance. When I was 28 in a committed relationship, I got pregnant. From the beginning, I knew something was not right. I'm not sure how I knew, but I did. The practitioners listened to me at Planned Parenthood. After a couple of months of the ominous feeling that things were not going right, I went to Planned Parenthood to terminate my pregnancy. I have to say it was the hardest decision of my life and one I never planned to make. I felt so fortunate that I had the choice and remembered going to DC with NARAL to march for this very choice I was making. I did not make this choice alone. My partner was there with me. He was very supportive. I have known friends who went this route alone. The doctor who performed the abortion confirmed that things were not right with my pregnancy from what he saw. Planned Parenthood was very nice to me and very supportive in the emotional afterthoughts and recovery period. I really appreciated Planned Parenthood for being there for me. A year later, my partner and I decided to have a baby. All went well that time, and I could tell the difference. At that point, I had health insurance and opted for a home birth. I always remember Planned Parenthood as a loving environment that provided me the care I needed.
Good afternoon. My name is Galina Bacena, and I'm the Policy Director for NARAL Coaches Virginia. Shortly, we support...
Take one step
Okay.
forward. There you go. Thank you.
Shortly, we support all three of the bills, and just to reiterate a point, it's time for the Virginia Legislature to trust women to make their own healthcare decisions. It's time for Virginia Legislature to trust doctors to do what is best for their patients, and for professional associations and Department of Health to regulate them appropriately, just like they do with any other medical procedure. Thank you.
Thank you. Yes, ma'am.
Good afternoon. Thank you for having me. I am a constituent of Delegate Rodman. I am in support of HB 450. I'm a mom to 3 young girls, and I want to live in a state that respects the dignity in their choices and respects their ability to make those choices and doesn't put additional stopgaps in there that make it make them unable to do so. Thank you.
Thank you.
Good afternoon. My name is Lisa Fleming. I live in Chesterfield County. I'm a member of Liberal Women of Chesterfield County, and I came here today specifically to voice my support for Delegate Rodman's bill. I didn't realize that there would be 2 others here today as well, and after hearing about those bills, I want to voice my support for all 3 bills and urge you to support them as well. Thank you.
Thank you.
Good afternoon. I'm Paulette McElwain with the Virginia League for Planned Parenthood. I'm the President and CEO of BLPP. We support all 3 of these bills, but I just wanted to make a couple points about Delegate Rodman's bill, HB 450. The requirements in the law right now are medically unnecessary. They're politically motivated. And data show that none of these restrictions change women's minds. They simply add barriers to women accessing care. And so that is the reason why we support this bill. I'd also like to make a couple points about HB 1037. Third trimester abortions are exceedingly rare. And when they happen, these are almost always really wanted pregnancies, and they are very tragic situations. So we are adding barriers into a situation where they're simply not necessary. Doctors and women are prepared to make these decisions. It simply adds politically motivated barriers where we really don't need them. This bill, sorry, I have all the cold everybody else has. So this bill, no, I'm good. So this bill inserts 3 doctors into a situation where a doctor and a woman can make these decisions. So we support this bill. So thank you all very much.
Thank you. Yes, ma'am.
Good afternoon, Mr. Chairman, members of the committee. My name is Margie Del Castillo. I'm with the Virginia Latina Advocacy Network, and we support all 3 bills
wanted to let you know these medically unnecessary restrictions that we're talking about today, they have a real impact on access. The number of clinics offering first trimester abortions has declined from 21 to 15, and over 92% of Virginia cities and counties have no abortion provider, and approximately 54% of Virginia women live in such a city or a county. So for those reasons and many more, we support all three bills. Thank you.
Thank you very much.
Thank you, Mr. Chairman. Anna Scholl, Executive Director of Progress Virginia. I would note that I am Delegate Bell's constituent, and I grew up in and was a constituent of Delegate Klein's for several years as well. So I've got almost a third of the panel covered.
But you broke out of that thing. You're living the dream now.
I would note that we do support all three of these bills because we don't believe that abortion should be singled out for a different level of restriction and regulation than other like healthcare providers. As you may be able to tell, I am expecting another child. And when my husband and I made the decision that we wanted to add to our family, we didn't have to hear government written materials about what a pregnancy would be like, or wait through a government mandated waiting period before I was allowed to conceive a child. And if something should go wrong with this pregnancy, or we should make the decision that we no longer want to have another child, I don't believe that government should interfere in that decision either. Thank you.
Thank you.
Good afternoon, Mr. Chair and members of the committee. I'm reading on behalf of Rachel Hood of Norfolk. In the summer of 2016, I found myself unexpectedly staring at a positive pregnancy test. My birth control had failed. While both my partner and I had full-time jobs, we certainly weren't prepared financially or otherwise to care for a child. I also have rheumatoid arthritis, which involves chemotherapy-level treatments every 2 weeks to manage the disease. No treatment that I could find had any clinical research on the immediate or long-term effects of these intense medications on pregnant women or their unborn children. The risk of pregnancy for myself and any child that would result was too great. Knowing the decision to have an abortion was the right one, I still had to go through an unnecessary ultrasound, through all the forced procedural requirements that are put in place by legislators and not doctors with backwards intent to create unnecessary barriers to this safe and legal procedure. Thanks to health centers like Planned Parenthood who make access feasible for people in my walk of life, I was not only provided access to a safe abortion, but also able to have an IUD placed shortly thereafter. Having access to a health center like Planned Parenthood completely changed my reproductive future. I also had safe access to abortion services that I chose due to the high risk of my health and any future child's health. And I was also able to ensure I was protected for years to come. Thank you for your time.
Thank you.
Hi, my name is Ashley Crocker. I am Delegate Bell's constituent, and I am expecting my first child in April. And as someone who is expecting, I hope that people are able to choose how and when to start their own family like I am.
Thank you. Yes, ma'am.
Mr. Chairman, members of the committee, I'm Nicole Pegar, represent the American Congress of Obstetricians and Gynecologists. We support HB 450 and 1037. Delegate Congress Waller had spoke of our statement on this general issue, and we just want to reiterate that we believe that the bill seeks to nullify the code section that interferes with the ability of the physician to make the best clinical decision for the patient. And for that reason, we support the bills. Thank you.
Very much. All right, anyone else in favor of any of these bills, please come forward. If not, anyone in opposition, we would welcome the testimony this time.
I just want to say my name's Al Durante. Bobby Orrick is my representative. I just want to say that I've been here every day this week and last week that these bills were before House committees in support. As you might notice, I'm a male. I worked for 17 years in East Texas before I moved here, where there was no shortage of pro-life bumper stickers. One phenomenon I noticed is that most of those cars were driven by gray-haired white men. I think it's time we let women make the decisions that are going to affect their lives. By restricting abortion, we're not going to say you can't legislate what people in their most desperate times are going to do with their bodies. Okay? By restricting abortion, you will not, from a pro-life standpoint, you will not keep women from having abortions. You'll just endanger their lives. So I support all these bills. Thank you.
Thank you. Okay, now we're going to transition to
Thank you, Mr. Chairman, members of the committee. Bill Janis here on behalf of the
Family Foundation. We oppose all three bills, but in the interest of time and brevity, we're going to focus primarily on House Bill 1231. Several of the prior speakers who were speaking in favor of all three measures, but in particular 1231, spoke about removing medically inconsequential regulations and requirements and restrictions that were unnecessary, sham restrictions, and leaving the decision really in the hands of the woman and licensed medical professionals. So I just want to focus in on that element of what this bill actually does. When you look at what the bill does, at 1231, beginning right around line 490, it dramatically expands the scope of practice for who may provide an abortion in Virginia. They take the term perform abortion, which is in the pre-existing code language, and replace it wherever possible with provide. They expand the definition to include now not only nurse practitioners and nurse midwives, but also during a first trimester abortion, any person acting pursuant to the orders and under the appropriate supervision of a physician licensed to practice medicine or osteopathy who is acting within the physician's scope of practice, without regard to any medical licensure or credentialing. So this, in effect, says first trimester abortions could be performed by someone under the supervision of a physician without regard to medical credentialing. Furthermore, if you go back into the section right around line 225, I think it is, where they're talking about the judicial consent bypass. In the judicial consent bypass language, at several places they strike the term physician, which is existing law, and replace that term with healthcare provider. Now, healthcare provider is a term of art in the code. It's at section 8.01-581.1. And healthcare provider encompasses not only doctors and doctors of osteopathy, but it also encompasses dentists, pharmacists, registered nurses, licensed practical nurses, nurse practitioners, optometrists, podiatrists, chiropractors, physical therapists, physical therapy assistants, clinical psychologists, clinical social workers, professional counselors, licensed marriage and family therapists, dental hygienists, and as someone who could not perform or provide the abortion, but would be competent to testify in a proceeding involving judicial consent for bypass to parental consent for a minor to receive the abortion. So while this legislation and all three of these bills purport to be about leaving these decisions in the hands of licensed medical professionals, what you have is an unprecedented expansion of the scope of practice from just physicians, medical doctors, and doctors of osteopathy to include, at least for the purposes of performing the procedure, nurse practitioners, midwives, or any person under the supervision of a physician without regard to medical credentialing. For these reasons, I think to call these provisions about safe legal abortion, or to call these provisions about removing medically inconsequential, unnecessary, or sham restrictions, I think is a mischaracterization of the practical legal effect of these language changes to the Code of Virginia. For these reasons, for all the other reasons that we normally oppose this legislation, we oppose both House Bill 1231 and also 450 and 1037. I thank the chairman and the members of the committee for their indulgence. Thank you, sir.
Good day, Mr. Chairman, members of the committee. My name is Olivia Turner. I am the president of the Virginia Society of Human Life. I'm also a woman who had an abortion. I've listened with compassion and care to all of the women who spoke today on behalf of their own life experiences and stories, and it's because of their life experiences and stories that the Virginia Society for Human Life opposes all three of these bills. As you can imagine, we are very pleased that Virginia has had long-fought struggles to pass these protective laws. We want to see these protective laws maintained. We recognize in particular that it is because these laws are in place that our abortion statistics are coming down every year in Virginia, because greater access to information, particularly prior to the abortion in the first trimester, is giving women options they would otherwise not have. We do not want to see these laws overturned because our grave concern is that it will lead to the protection of unscrupulous abortionists and create, in situations throughout Virginia, opportunities for those abortionists with no regard for the well-being of the women who come through their doors to operate in ways without checks, without balances, and without oversight from this body. These restrictions, these operations, these laws were well thought out, and advocated for. I urge you to maintain our standard of protection and respect for the dignity of women and their unborn children. This is a human rights issue, so to hear men speak on behalf of the protection of women in the Commonwealth pleases me, particularly as a woman who has experience. So I applaud all of you and thank you for your patience. Good afternoon.
Thank you very much.
Thank you, Mr. Chairman, members of the subcommittee. Bill Ray with the Virginia Catholic Conference. We oppose all three of these bills for the reasons stated here and for the reasons that you've heard in years past. I would just add one other thing. As long as all of our Catholic social services and charities remain open, there are no unwanted children. We have adoption services. We want the child. No matter what the diagnosis is, no matter the cost, no matter the disability, give us the child. And we would say that to anybody facing an unplanned pregnancy. Please, give us the child. Thank you.
Thank you very much. Any other testimony on any of these bills? Any members of the subcommittee have any questions for any of the patrons? Do any of the patrons have any desire to add to or counter anything that was uttered by any of the witnesses?
Yes, I'd like to have Gail respond to some of the comments that were made. That'd be okay?
And if she's going to do that, I may let somebody respond to her. So go ahead. Sure.
You think I won't like that?
No, just let you, whoever it is, you go find the hall.
It's the choice to put a litigation attorney in this room.
Right.
Every year they make that choice.
So just with respect to, while that was an impressive list of, who qualifies as a healthcare provider in Virginia, if you look at lines 261 through 263, it very clearly addresses that issue within the parental consent section of the bill, that nothing contained in this section shall be construed to authorize a healthcare provider to provide an abortion to a minor in circumstances or in a manner that would be unlawful if provided to an adult. And then if you further look down to starting at line 46, and then going through line 492, very clearly explains the parameters of who would be allowed, permitted to provide a lawful first trimester abortion. And then if you further look down to line 493, it explains that only physicians can provide a second trimester abortion. So this would not permit podiatrists to perform an abortion if they didn't have accurate training, if it wasn't within the scope of their practice, and that's very clearly pointed out in the bill. And additionally, with respect to nurse practitioners, licensed nurse midwives, physician's assistants, all of them must operate under a practice agreement in consultation with a physician. And those practice agreements they're in 54.1. They're regulated by the Department of Health Professions, and they set the individual scope of practice for each of those providers. So if first trimester abortion care was not within the scope of practice for one of those advanced practice clinicians, it wouldn't necessarily be in their practice agreement. So that's sort of the check there in making sure that the only additional clinicians that would be permitted to provide first trimester abortions under this change to the bill would be people who had the adequate training, experience, education to provide that care in the safe manner that providers in Virginia have been providing to their patients since 1970. So we certainly do not support any relaxing of the current standard of care, and this bill was very carefully crafted to make sure that the standard of care was maintained while removing burdens that do not have a substantial enough medical benefit to justify the impact that they've had on abortion access.
Okay, thank you. Mr. Janus.
Thank you, Mr. Chair, members of the committee. In response, I would just say, if you look at line 228, right, it's clear that the threshold inquiry that has to be made, the threshold condition precedent, the judicial bypass for parental consent, is that there be a showing that the minor's abortion decision, right, that the minor is mature enough and well enough informed to make the minor's abortion decision in consultation with the minor's healthcare provider, independent of the wishes of any authorized person, right? It doesn't say the healthcare provider who performs or provides the abortion as defined later on in the code section when it expands it beyond physicians and doctors of osteopathy to include nurse midwives, nurse practitioners, and any other person who's under the supervision and direction of the doctor without regard to medical credentialing. So I think the point I probably didn't make as clearly at the beginning was this does allow anyone from a licensed marriage counselor, optometrist, as a healthcare provider in Virginia as defined in Section 801. It may not have been drafted with that intent, but that's certainly the legal consequence of it. That's the legal effect of it. So no matter how carefully it was drafted or what the intent was, this now, the threshold inquiry that has to be made in the case of a minor seeking consent or a judicial bypass to normal parental consent would be consultation with a healthcare provider, and a healthcare provider is defined as a term of art to code to include everybody. We won't let an optometrist in Virginia do any kind of treatment that's invasive, medically invasive in nature. They can't administer hypodermic needles. But in this case, they could consult with a minor seeking a judicial bypass in order to make a determination that they would, as a threshold inquiry, be able to get a judicial consent to bypass the parental consent. And once again, even without that list at Section 801, the expansions that occur for first trimester abortions, in fact, second trimester abortions also allow any person acting pursuant to the orders and under the appropriate supervision of a physician licensed to practice medicine or osteopathy who's acting within the physician's scope of practice, not the person's scope of practice, because as this is written, it doesn't require that person to have any medical licensure or credentialing in the Commonwealth of Virginia. So they won't even, won't even have the credentialing of, say, a licensed marriage counselor, which is required in Section 801. This does, what this does is it's a unprecedented expansion of the scope of practice, not just because it expands it to nurse practitioners and nurse midwives above and beyond doctors of osteopathy and medical doctors, but it also expands it to any person acting under the supervision without regard to any medical, without any requirement, without regard to any medical license.
Thank you, sir. Delegate Watts.
Thank you, Mr. Chairman. For clarity, a narrow question of the previous speaker. I wanted to be sure that the wording of the bill does not in any way reverse Virginia's long-standing practice that, or law, that second trimester abortions must be performed in a hospital, and therefore they would be performed by someone with hospital admitting privileges.
This absolutely reverses that.
It does.
That is perhaps the most unconstitutional restriction that's in the code right now. So yes, that is reversed. And North Carolina has never required second trimester abortions to be provided in a hospital or an ambulatory surgical center. I don't know off the top of my head how many other states allow second trimester abortions to be provided in an office setting, but really this is about trusting the Department of Health Professions and the Board of Medicine and the Board of Nursing to regulate their professions, to regulate professionals who are licensed. We do not impose up to 10-year felony prison sentences on doctors who violate the standard of care. We have a procedure for that in Virginia, which is called medical malpractice. We have a whole section of the code. That is how that is dealt with. When you have a healthcare provider, and that's what abortion providers are, they're healthcare providers. They are medical doctors. They are licensed nurse practitioners, if that is permitted. They are at risk of losing licensure. They're at risk of losing their livelihood and at risk of having a civil judgment against them for up to the cap in Virginia. So this is about trusting the medical profession to regulate itself and to regulate abortion care the same way that it regulates similar procedures. Colonoscopies and certain types of plastic surgery procedures are performed in an office setting in Virginia. We don't punish those doctors with 10 years in prison if they do something that is against the standard of care. But that is currently how the abortion scheme in Virginia is set up with respect to these criminal laws. It's a quite extreme penalty. 10 years in prison if you are wrong about what trimester it is. If you perform an abortion on someone who's 14 weeks and 2 days instead of 13 weeks and 6 days, then you are now at risk of being convicted of a felony for up to 10 years in prison, a mandatory minimum of 1 year in state prison. So that's what this bill is doing. This bill is asking this body to treat abortion providers like doctors, like licensed medical providers, the same way that we treat medical providers that are trusted and regulated by the Department of Health Professions in Virginia. Because if we don't trust them to regulate abortion providers, why do we trust them to regulate other types of procedures that are performed in office settings? We know that this is safe in other states. It's safe here. And basically asking for this not to be criminalized anymore, for this to be regulated the same way that other physicians are regulated. And with regard to the inspections, the Department of Health Professions also has an entire booklet that I have with me that lists all of the procedures for responding to complaints. The same way that would happen in any other kind of medical office setting. So that is what this bill is doing. It is asking to not be stigmatizing people who need abortion care anymore, and to be treating them with dignity, and to be respectful of their constitutionally protected decision, and then to also stop discriminating against the abortion providers who put their lives on the line every day to go to work. What other medical profession requires you to think about having to put a bulletproof vest on you before you go to work in the morning? These are committed professionals. These are some of the most caring professionals I've ever.
Answered the delegates' questions. I would just, that's okay. I appreciate that you're passionate about it and well informed for that matter. So we appreciate your depth of knowledge.
And I very much appreciate that you all have listened to everyone that came up here today, and the respect that all of you have exhibited.
Well,
so thank you very
I will
much.
say to that point, and you're welcome to stand there and be the target of my. I appreciate you saying that. Those who feel deeply about this issue on either side, the opportunity to find common ground is going to be rare because of how strongly people feel about it, but I think we can at least be civil to one another and hear each other out. And so I hope that we've been able to accomplish at least that, and we'll see what happens after that, but thank you for that. Yes, ma'am.
Thank you.
All right, anybody on the panel wishing to respond to anything that's been said? Anybody else in the audience wishing to speak? I was about to ask if any of the other patrons wanted to say anything else. Okay.
Mr. Chairman, members of the committee, I want to thank you also for having this hearing today. You know that I spoke out about a very personal, my personal feelings about this on Monday. And I just want to, for the record, to be known that I had a number of our colleagues who approached me after the fact to thank me for sharing my feelings about this. I really believe that we need to put this issue behind us and move on so that we can find common ground on other things, so that we can solve the kitchen table problems that all of our constituents are facing. If we would repeal these unmedically necessary restrictions on women's right to choose and move into another chapter in the Virginia General Assembly and find common ground. I ask you wholeheartedly, this comes from a place of very strong personal feelings, but I know that many of our constituents also share these same feelings. We believe that elected officials should not be making these decisions for women, for families, for doctors. It doesn't happen in any other medical profession. And
Can I just respectfully say that that is not necessarily who we are, some of us make those decisions for any folks you named, that there is another person involved that we regard very highly in this discussion. And that is where we can't agree.
okay, and I respect that. I want you to know that I respect all of you. Good people see things differently. I come from a religious background which doesn't see it the same way as you, and I think that we all need to remember that we're here to support the Constitution, which has deemed these things unconstitutional. And with that, I will thank you for your time, and I respectfully ask that you move HB 1231 on to the full committee. Thank you so much.
Yes, ma'am.
Sure.
So procedurally, okay, go ahead.
I was going to ask how you wish procedurally to proceed with three bills, sort of, all three sort of put in front of us.
One is broader than the other two, so I would entertain a motion to roll House Bill 4, to incorporate House Bill 450 and House Bill 1037 into House Bill 1231. Would that be a proper motion, Mr. Hoover, Chair?
Mr. Julian,
do think that my bill is a little more specific with just changing the number of doctors from 3 physicians to 1 physician. So it's a little more of just a technical change on a portion of the bill versus an overarching change. So I would hope, I'm asking that it would please be considered separately.
Okay. Delegate Herring.
Oh, I apologize, I'm dead.
Delegate Watts.
Basically, at parliamentary inquiries, I try to parse the procedure. If I had always assumed that you vote on, if you vote on the broadest first and it fails, then you should be able to vote on the next broadest and the next broadest. And if we've incorporated them in, we would not have that opportunity. Am I not correct?
That would be correct.
Therefore, having voted on the prevailing side, I would also move that we do not incorporate the other bill and that we vote on them separately in a parliamentary procedure.
Okay, all those in favor of reconsidering the vote by which we incorporate House Bill 450 and House Bill 1231, say aye. Aye. Opposed? All right. So it's now back in its original posture.
Mr. Chair, are we at the point where all 3 bills are done before us?
Yes.
For action? Okay. Mr. Chair, before we start, I'd like to second what several speakers have said. This is an issue of not first impression. This has been for us in various forms and formulations for most of my tenure, and we have had meetings much less civil. I hope listening on both sides in this one. So thank everybody for the manner in which the great issues that are very important to them were presented. Now the time's come to press and take action on the bill. I will move. We'll just take it in order. I would move the PBI House Bill 450.
Why don't you start with the broadest one, since that appears to be the point of contention.
I remove that. I reverse that motion and move that we PBI House Bill 1231.
All right, there's a motion PBI House Bill 1231. There's a second. There's a second. Delegate Collins. Sorry.
I wasn't going to speak on either motions.
Okay. You're welcome. We have 2 minutes if you wanted to use the opportunity to say anything you wanted to say.
First of all, I am a constituent of Senator Vogel. I know that's been an issue here today. I wanted to say that Delegate Boysko and I both gave passionate speeches on the floor, and she and I have spoken. I've also spoken to individuals amongst your group, and I understand this is it is a sensitive issue on both sides, and it is with heavy heart that this continues to be trench warfare, that no one wants to make a movement on one side or the other, when there is common ground out there that we all can achieve. As an adopted child, I know if you paid any attention, I'm not going to belabor the point, but there's a long list of adoptees from the early 1970s from Lynchburg, Virginia, because through Catholic Charities, because there were organizations that stepped up to take in pregnant women who had no other option. And I recognize, I'm not trying to make a debate here, but my door, 420, is open. Please, feel free, let's have a conversation, because I think that we all have a singular goal in mind. Thank you.
All right. The motion is to PBI. Please cast your vote. Close the roll. All right, that bill is PBI. Delegate Bell.
Mr. Chairman, sorry, I turned the page. The next bill before us, they appear to be similarly broad.
Choose one or the other.
That's fine. I would ask that we take House Bill 450, and I would move that the subcommittee PBI House Bill 450.
Is there a second? Any further discussion? There are 2 minutes afforded per side. If any of Delegate Rodman, if you want to take any of those 2 minutes, you're welcome to do that.
I just want to thank the chairman and the committee for giving us this time. I know that, we have maybe talked about this as being on 2 different sides, but I think in the end, we are talking about women's rights to be able to make their own decisions with their doctor. And I do think that is separate from some of the discussion that's been made. We continue to have these conversations, and I know that you respect women and that you respect your daughters and your wives, but this is a moment where, as Virginians, that we need to step up and listen to the women out there. And I'm grateful for the time that you gave to us today, and we'll continue these discussions. Thank you very much.
Thank you. All right, the motion is to PBI. Please cast your vote. All right, the bill is passed by indefinitely. Delegate Bell.
Mr. Chair, the remaining bill is House Bill 1037 from Delegate Congress Fowler. I move that the subcommittee PBI House Bill 1037.
Delegate Klein seconds. Delegate, do you want to have those?
Just to thank the committee for their consideration, and just to think about, this is about women's health and their rights to decide with their doctor.
Thank you. Any further discussion? Please cast your vote. All right, that bill is passed by indefinitely. Please close the roll. Delegate Watts, you have something in that vein?
Thank you, Mr. Chairman. House Bill 298. Perhaps the way to introduce the bill this year is in fact to reference a comment that was just made, and that is that for many in this decision about being parents, that there is a third person involved. And the bill before you about the status of birth control is that basic decision about when does life begin. Does it begin at the moment that egg and sperm meet? Or does it begin when the fertilized egg is implanted in the uterus? The very definition, the very word contraception, means that it acts to prevent conception by the implantation of a fertilized egg in the uterus. And I wouldn't be one of a long line of women carrying this bill, which goes back to 2003, if there wasn't a strong advocacy out there that the moment that conception is defined as the moment that egg and sperm meet. And you have perhaps some of you who have been on what has typically been a special subcommittee have seen me bring up two newspapers that I was handed on 2 separate years from groups that advocate very strongly that birth control is abortion because it stops a fertilized egg from implanting in the uterus. And as you read these articles, they are very specific about birth control pills as well as IUDs, and on down the long list, because ultimately these operate, even birth control pills, if they don't stop the fertilized egg from coming down the path, they will stop it. The birth control pill can operate to not have it implant. Therefore, the bill before you is saying that anything approved by the Federal Food and Drug Administration as birth control will not be regarded as an abortion under the laws of the Commonwealth. And it's as simple as that. And I will just address one other issue before we hear from others. And that issue is the last time I was able to present this, the year and a half ago, or 2 years ago, it was mentioned that, but by referring to the Food and Drug Administration, that is not really something we do in Virginia Code. So of course, now with the ability to quickly do a word search, I find that in fact there are 44 specific references to Food and Drug Administration. Some of them having to do with insurance, but some of them having to do with various practices and certainly prescriptions, very much in the healthcare field. so that this bill before you is in keeping with the frequent practice where we have made reference to that body of research that comes out of the Food and Drug Administration. Again, I hope this will be the year that we make that basic decision that means of being responsible parents, which start in responsible actions, will not outlaw what some figures show as high as 97% of people use, which is some form of birth control as approved by the Food and Drug Administration.
Thank you, Bill. All right, anyone in the audience wishing to testify in favor of this bill, please come forward.
Mr. Chair and committee members, Jennifer Allen with Planned Parenthood Advocates of Virginia. Thank you for the opportunity to speak in support of this bill. I'd like to say, we were talking with earlier bills, Mr. Chair, you suggested that it's very difficult to find common ground on issues about reproductive health. The truth is that birth control is the place where we should be able to find common ground, allowing people to prevent pregnancy and being able to share in increasing the public health of the Commonwealth and support folks' ability to control their own lives. We strongly support this bill and urge your support for it as well. Thank you.
To that point, last year I recall there were a number of us who voted in favor of a bill, I believe, carried by Delegate Fillercorn. It may have been last year, maybe the year before, that extended access to women for birth control for, was it up to a year without having to get additional prescriptions? So, again, to your point about cooperating, we certainly agree that on the front end is perhaps where we should be concentrating our efforts and not after the fact. There are some implications of this bill, as I understand it, that differ from that kind of clean point of agreement, but I suppose we'll hear from folks who will educate us about that in a minute, but thank you for, I didn't mean to interrupt you, thank you for coming forward. Did you have anything else you wanted to add?
No, well, yes, one thing just to your point, Mr. Chair, thank you for saying that, and I would just say that I think that Delegate Watts has really addressed this by leaving responsibility where responsibility lies. The FDA classifies things as birth control, and so the Commonwealth following along with those standards makes great sense to us, and we hope that y'all can support that. Thank you.
Yes, ma'am.
Mr. Chairman, members of the subcommittee, I'm Nicole Pugar again, representing the Virginia section of the American Congress of Obstetricians and Gynecologists, and we just want to say that we support the bill. We believe that the medical definition and the FDA's definition of birth control is appropriate, and for that reason we support the bill.
Thank you. Lawyer.
Hi. The ACLU of Virginia supports this bill.
Thank you very much. Yes, ma'am. All right, anyone else in favor or at this point in opposition to the bill, please come forward.
Thank you, Mr. Chairman, members of the committee. Bill Janis on behalf of the Family Foundation speaking in opposition to House Bill 298. In typical fashion, Delegate Watts is not only a close student of the law, but she's a careful student of the law, and she's really kind of defined the crux of what this is all about. We're talking about contraception, which is steps to prevent conception. Now, what the language of this bill does, by incorporating my reference Title 18.2, and using USF Food and Drug Administration as the ultimate arbiter of what would be considered birth control in the Commonwealth of Virginia, is to expand the common understanding of contraception, which today encompasses methods and techniques to prevent pregnancy by either preventing ovulation, or fertilization, or implantation through various either mechanical or chemical means. It expands it to include drugs that are on the US FDA approved list, it's Title 18.2, such as Previn and Plan B, which don't prevent ovulation, they don't prevent fertilization, and in most circumstances don't prevent implantation, but induce an abortion. And they are abortifacient in their effect. And so for this reason, the Family Foundation of Virginia respectfully requests that you not pass this legislation and expand the definition of contraception to in effect be post-ception, which is a chemical that would be used after the conception has occurred and even after implementation to chemically induce an abortion. So for that reason, we oppose the bill, and we hope you'll oppose it as well. Thank you.
Mr. Chairman, members of the subcommittee, thank you. Bill Ray with the Virginia Catholic Conference. We also oppose this bill for the reasons just stated here. The issue with the expansion of the definition and certainly would be a change in that regard. Thank you.
Thank you.
Mr. Chairman, again, Olivia Gans Turner with VSHL. We do not at VSHL have any position whatsoever on contraception unless the definition, as in the case with this law, is vague to the point of not preparing or providing provisions that acknowledge new drugs that are being developed that do in fact directly attack the new life that maybe has come along. RU46 is not currently part of the FDA definition, but we know we do not have a position, for instance, on Plan B at the Virginia Society of Human Life because our understanding of how it works at this stage of the game and in most tracked cases of the use of the drug, if a pregnancy has begun, the pregnancy will continue and a woman has to make a decision about whether or not she might proceed to get a more traditional form of abortion. But the current understanding, our understanding of how the morning after pill works is that it does not end the life of a newly developing unborn child. However, our concern is that there may be and are new drugs in that arena being developed. So we would like to see, if there is movement on this, that clarification occurs that guards against any understanding that a drug that is now or is in development for public usage could in fact, and does in fact, end the life of an unborn child. So clarification is our point of concern here. So for that reason, we'd ask you to oppose the HB 298 because of the vagueness. Thank you very much.
All right, thank you. Delegate Wise.
I honestly don't know what part of my thinking to share with the committee. And that is that vagueness, again, is one of those, it really is a deep moral, religious decision when you think about what vagueness means in this progress of when does a human life begin. There are as many different feelings and moral convictions about this as there are adults in the Commonwealth. I believe that this does draw the proper line in deciding to be very responsible in any sexual activity to make sure that you use the proper protection so that when you have the joy of becoming a parent, it is a conscious decision to be a parent.
Any questions for Patron? Any motion?
Move to report. Second.
Motion to report has been seconded. Delegate Klein. Mr. Chairman, substitute motion to PBI. Motion to PBI is second. Is a superior motion. And Delegate Watts, did you want to take any more time? Okay. Any members of the subcommittee wish to speak to the motion? Otherwise, please cast your vote.
No.
Watts is a no. All right, please close the roll. That bill is passed by indefinitely. Thank you.
Thank you, Mr. Chairman. Thank you.
Mr. Chairman. Delegate Bell.
I was trying to caucus people that are here, perhaps just, you have a half hour, is that right? Mr. Chair, we have some of our regulars that are here in convenience, which is bad. We also might have some people from. I might suggest, Mr. Chair, that we have to see if you're on the board, so he doesn't take up the time.
Who has come a long way today to testify about the bill? Anybody? Raise your hand. You're here a long way. Yes, sir. What bill are you here for?
638.
What is it about?
Dealing with aviation drones, trespass. crime commission bills. I guess maybe Delegate Bell had too much on his plate and didn't want to take them, but these are really good bills, and Delegate Bell and I have worked on these together over the years. So you may recall several years ago we began adding misdemeanor conviction offenses as grounds for taking DNA from defendants, and this is really in the aftermath of the Hannah Graham tragedy in Charlottesville. And then we added, I think it was 9 more misdemeanors in 2015. Last year, Delegate Landis and I had a resolution that asked the Crime Commission to take an even closer look at the relationship between misdemeanor offenses and felony offenses, with an eye towards trying to figure out whether we want to add some more misdemeanor offenses to the list of those for which we would take DNA after conviction. And the Crime Commission did an unbelievably great study, spent a lot of time on it, and made the presentation to the staff made the presentation to the Crime Commission, I guess in late fall. On the basis of that, there were 2 bills that were recommended, and then 1 bill came later in the area of fingerprinting that I think the Commission staff felt was necessary to clean up some technical issues with the fingerprinting laws. So bill number 1, I think is 1249, and 1249 adds 4 misdemeanors to the list of offenses requiring a DNA sample from adults upon conviction. Assault and battery under 18.257, domestic assault and battery under 18.2-57.2, petty larceny, and trespassing. There's a second bill that adds 3 more to the list, and those 3 are destruction of property, obstruction of justice, and concealing merchandise or altering price tags. Each of these bills has a different fiscal impact. I think you've seen the impact statement. One is $453,000, yippee, and the second one is $646,000. Those bills have been heard because budget amendments were put in for both of them, and the budget amendments were heard before appropriations yesterday. We have some of the staff of the Crime Commission who can further enlighten you on their study. Several of you have already heard it, seen it, felt it, and acted on it when the Crime Commission met in the fall. So that's the nature of 1249, is to expand to 4 additional misdemeanors, and 1264 takes it to 7 additional misdemeanors.
Okay. So about half of us had the benefit of the Crime Commission report, and who would be the best to present this? So just a very, very quick version. So for the benefit of those who were not there, the facts were that in the Graham case, Jesse Matthews, right? Matthews.
Matthew.
That's what that. So Jesse Matthew had his DNA collected from a previous attempted rape case, and it was sitting in the system. He subsequent to that was charged, arrested, and convicted of trespassing. For the trespassing charge, even after conviction, no DNA was collected because that wasn't part of the system at the time. He then wandered on his way, committed at least 2 more murders that we know about, and that was the genesis of a desire to look at it a second time. We asked the Crime Commission to do a deep dive into what other sort of backwards looking, what offenses then, if you commit offense A, what offenses lead you, we see down the road that you commit felony B. And to the surprise of many of us, including myself, the crime list that was just propounded, some of which seemed pretty modest, actually have a high, where I want the Crime Commission to use the right term.
Pre-crime list.
High what? Well, you told us don't use probability.
Relationship or association.
High association with, so they're very careful to say it doesn't predict the future conduct, but that this list had a surprisingly high association with. So that was the basis for the bill. The fingerprint bill is a cleanup that goes as follows. You don't currently take fingerprints when you get a trespassing charge. From the dawn of time, that's been the case. And the thought was, if we're going to take DNA, we certainly should add trespassing to the fingerprint list. So I think it follows with this. If you do them, you should do both. If trespassing is for some reason kept off the list, then I'm not sure that the trespassing fingerprinting bill is a freestanding idea. And in terms of the cost, some of the costs have been borne, if you will, by the perpetrator, but there was additional costs through staff at the forensic sciences, is that right? Okay. Because it has cost, and if we did report it favorably, it would be to report and refer. Okay. And I think that's, does anybody at this point have any questions for the patron or the crime commission? Delegate Herring on the crime.
Thank you, Mr. Chair, and I am on the crime commission, but I know I had some concerns and hesitation with petty larceny, and I guess we'll get to the next bill, but can you just refresh, I remember when we talked about the high association, but I think it was figures that were presented. I just wanted to get that out there because I know that will be a concern for others.
Sure. Mr. Chair, members of the Commission, Kristen Howard, Executive Director of the Crime Commission, and to answer your question, Delegate Herring, yes, there were a number of crimes, 7 that we identified that showed a relationship with having other future violent crimes or having those in their past. And there were a varying level dependent upon those crimes as to where that fell, as to whether it was a stronger or a not as strong. And so the highest 2 that had the most compelling relationship were the assault and battery convictions, which were the assault and battery against family or household member. But then the next ones were trespassing, petty larceny, destruction of property, and they were also strongly associated, and that was seen in both of the analyses that we did. And then the obstruction of justice and the concealing merchandise, the altering of price tags, and that was a strong association in prospective analysis, and that was higher than seen in the retrospective analysis. So it was a varying level depending upon the crimes, but they were the top 7 that were identified beyond all the other crimes that we looked at.
Delegate Klein.
So, when you examine, say, petty larceny, and you look at what crimes, I don't know, that a perpetrator may commit down in the future, what crimes did you determine are more likely to be committed by someone convicted of petty larceny?
Well, we did look at it in the more likely to commit them. We looked at it, so we received a lot of information from the Virginia Criminal Sentencing Commission, and so we looked at the petty larceny charges and then their future crimes that were committed by those subset of offenders. And we looked at violent offenses, murder, rape, sexual assaults, and some burglary offenses. So we isolated it to just those most violent offenses.
So you found that those who commit those violent felonies have priors, and some of them and are more likely to have priors related to petty larceny, assault and battery, domestic assault and battery, trespass.
Yes, so what we did, we also got about 3,100 criminal history records from the Virginia State Police and started with those felonies to see, well, what other crimes did they have in their past, and looked at all of the misdemeanors and felonies that they had been previously convicted of, and the misdemeanors that we saw were those 7 that were identified.
But you saw more than those 7, right?
We saw a whole lot of misdemeanors, but those
pretty much every misdemeanor, right?
I'm sure we saw pretty close to every one. I cannot say with certainty because we had quite a number of misdemeanors in that batch, but we even saw trespassing on the criminal histories, which is not a required fingerprint, but it was still captured in the criminal history because it's fingerprinted for sometimes.
What was the point? What point did you roll dice to determine 7? Did you just say, well, we don't have enough time to do more than 7? I mean, what determined that you stopped at 7 instead of 8, 12, or all of the misdemeanors?
I'll be happy to pull that data for you. So, for example, in the prospective analysis, we were looking at the 3,100 criminal history records, and we did counts of the misdemeanors. And so, was there one that you wanted to focus on specifically?
No, I'm curious because I don't know was there a large drop off after 7 misdemeanors, or between the 7th misdemeanor that is in these bills and the 8th misdemeanor that's in these bills, or did you just make it?
Yes, there was. Let me give you an example of kind of the presentation that was given for the crime commission members. So, for example, domestic assault and battery. 18% of the offenders who were convicted of domestic assault and battery were convicted of 4,200 subsequent felony sentencing events in the next 10 years. And so we saw 32 murders, 52 kidnappings, 32 rapes, 16 sexual assaults, 806 felony assaults, 83 robberies, 207 burglaries, and 775 larcenies. Then in the retrospective, let me give you those numbers as well so you can kind of see them side by side.
Did you determine whether any of those were unsolved for any significant period of time?
We were looking only at convictions, so.
Okay, so those were solved without the use of DNA on the misdemeanors.
Well, we can't say that they were solved because of DNA.
Correct. But the DNA was not taken from the misdemeanors.
For those 7 crimes, no.
And they were still convicted of the felonies.
That is correct.
Okay. All right, keep going.
And so, for example,
Of course, what we don't know about the people who were never convicted or caught, and that's the whole purpose, is to make it easier to catch those people who perpetrate crimes that were not discovered.
and so, for example, going backwards from the criminal history records, if you were to pull out murder, and so of the 104 criminal histories where murder was the most serious violent felony offense, 32 of them had at least 1 prior misdemeanor assault and battery conviction, 19 domestic assault and battery, 21 petty larceny, 21 destruction of property, and 12 trespassing convictions.
All right. So I see someone else nodding when I asked if there was a large drop-off. What was the 9th and what was the 8th and what was the 9th?
I'll defer to Christina. She is intimately familiar with the data.
Thank you, Mr. Chair, members of the subcommittee, Christina Arrington, Crime Commission staff. And essentially what we were asked to look at, again, is to see what, in addition to the existing 14 misdemeanors, could be added due to an association between a misdemeanor conviction and a subsequent felony. So we took 2 approaches.
It's probability, it's not an association.
Correct. Unfortunately, the nature of this data did not allow for a statistical bivariate correlation analysis to be performed because there's data assumptions that need to be met in order for that to happen. We tried, couldn't happen, and we couldn't do it in a responsible manner. However, in that same sense, there can be no argument that the data was manipulated in any way to show a stronger association one way versus another. So in the prospective analysis, what we looked at were, we looked at all misdemeanors that required a fingerprint plus trespassing and saw how many were convicted of those misdemeanors in FY 08 to 09. We then tracked to see how many were convicted of a felony in the following 10 years, with a specific focus on violent felonies and certain burglary offenses. Very clearly in that analysis, there were 7 that rose to the top, and quite frankly, if you look at the existing 7, you can almost see a drop-off within just the 7 as well. And I think to an argument that's made, well, they just make the list because they're the most common ones. When we look at petit larceny, there were 19,000 that were convicted in that 2-year period. 21% had a subsequent felony conviction within 10 years. But we also looked at DUI. There were 54,000 that were convicted of a misdemeanor offense, but only 8% were convicted of a felony in the following 10 years. So what that suggests is that there's something different between those convicted of stealing something versus those that are convicted of DUI. I hope that answers.
I have a better understanding of the data and how you approached it at this point. Thank you.
Anybody else in the panel have any questions for Ms. Arrington or Mr. Toscano? Okay, let's take public comment. Is there anybody in the public that would like to be heard either in favor of or in opposition to? Let's take these bills up together. If you have specific thoughts, you can certainly do that, but let's take up the bills public comment together. Oh my goodness, you've waited all day, buddy.
Let me support your bill, Mr. Chairman.
Okay. So, Delegate Gilbert has returned the amendments. So Delegate Toscano, at this point, if you could do the breakdown of the crimes again, just so we know exactly what
Sure.
we're looking at.
1249, which you have up on your screen, that's the more compact bill. That's adding 4: assault and battery, domestic assault and battery, petty larceny, and trespassing. That's 1249. 1264 adds an additional 3.
Does it just add the 3 or does it have all 7?
It has all 7. It adds an additional 3 to the 4 I just mentioned.
All 7.
So if you want the bigger bike, you do 1264. If you want a smaller
And remind
smidgen.
us what is added with 1264 in addition to the original 4.
The additional 3 are destruction of
Concealment, vandalism, and obstructing, right?
destruction of property, obstruction of justice, and concealing merchandise.
And then you had the fingerprinting for trespass was the freestanding bill.
That's a freestanding bill.
Okay, so, just so everybody understands what we're about to do. We have 3 bills before us, but they're really, you should not vote, we shouldn't do both 1249 and 1264. This would be a place for us to decide what should go in. There are 7 offenses. The 4, it's not about seriousness necessarily, but the smaller 4 would be assault battery, domestic assault battery, petty larceny, trespassing. And truthfully, we can pick and choose. And then in addition, we could add up to the vandalism, obstructing, and concealment.
Mr. Chairman, I guess I wonder, you know, if these are going to be reported up to appropriations, maybe both bills ought to be sent up there if you desire the bills to be, one of the bills to be passed, because then they could choose. Unless you wanted to not go with the bigger bill. If you wanted to go with the bigger bill.
This panel may not be where your big problem is. I think you're about to have a much more complicated discussion, not related to money for the full panel, because that's what happened last time. Is like,
Sure.
My memory was the crim sub, the time was perfectly comfortable adding to, and then we got the civil, and it limped out at half the size. All that said, my preference is we decide.
I know what
at this point,
limping
we think
feels
we should do what they good policy is, and then sort of.
That's right. I know.
Okay. All right, so we will entertain motions. Are you ready to take over? Should I finish? Okay, so I'll finish these bills. I will entertain any motion. We have 1249 is the smaller, 1264 is the larger, but again, we can make 1264 and then take some bills out of it. Things out of it, we don't run out stuck with the number.
What's the crime commission thing that
It's all 7.
all set?
So if you want to do the crime commission, you just do 1264.
I already voted for that. I know. Okay.
Not in this setting, and we're.
Mr. Chairman.
Okay, and this.
Oh, yeah.
Okay, Delegate Klein, want to talk some more? Or we gonna start?
Well, maybe this is a good time for temperature.
Okay. So Delegate Klein had asked us for temperature. We described this before. All hands here. All right, let's do temperature. Who is inclined with whatever work we do to vote for some version of 1264? All right, so that's the bigger.
Oh, okay.
All right.
Let me start with the smaller.
All right. Let's the.
Is everybody going to do the smaller?
Yes.
No.
Okay. You do whatever you want.
That's right. Who's the smaller?
Small.
Okay. Who would stay for the bigger?
Do both.
Okay. So maybe there's some of this.
Let's take the smaller.
Okay. We usually will let the patron play a role in.
Sure, let's take the smaller.
Okay. All right. So patron has moved that that patron's request we strike House Bill 1264. Is there a motion?
So moved.
Second. All in favor, signify by saying. Oh, we got. I'm sure I did this right. I'm sorry. Okay, so motion strikes for us, has to vote in the electronic voting board. Clerk, we'll close the roll, okay. And then 1249, which would be to add NB, domestic NB, petty larceny, and trespassing to the list, is now before us. Is there a motion?
Move the report.
Okay, motion is made and seconded to report.
Mr. Chairman.
Delegate Klein.
Doesn't have to be a report or correct.
It is, I apologize, report refer.
And speaking of the motion.
Delegate Klein.
All right, I didn't support this tree when it was created. I don't want to support adding to it, but this train is moving. There's a difference between felonies and misdemeanors for a reason. And we don't know if we are, right now we're on A and B, domestic A and B, petty larceny. All right, and trespassing. And I was not able to benefit from the study that the Crime Commission
CLU of Virginia.
Thank you.
On behalf of our 42,000 members, we ask that you vote against the bill. We have serious constitutional concerns related to due process and privacy with the way we already collect DNA with the existing list, and now we're going to expand and add more misdemeanors to Senator Klein's seeming line of questioning in a very arbitrary fashion. Is it 4? Is it 7? Is it 9? Is it all of them? In spite of the Crime Commission's statistics, if you look at the Department of Forensic Science actual data on the data bank, in spite of adding more misdemeanors in 2015, the number of crimes being cleared or assisted in being cleared is on decline. And there are 4 things that are not the violent felonies that our understanding is the data bank is intended to address. Additionally, as you add crimes to the list, you're going to naturally add to the number of samples in the database, and when you do that, you increase the risk of ethnic bias and false matches. So we are in strong opposition to the bill and ask that we vote no. Thank you.
Anybody else wish to speak in favor or against the bill? Okay, we have before us, I believe, the motion report and seconded. Is that okay, and refer, that's right, I was correct. So the motion before us, on House Bill 1249, is to report and refer to appropriations. Are you ready? Please cast your vote, and then I'm trying to go to board. Okay. And then the companion bill, just to remind everybody, we do not take fingerprints for trespassing. It seems bizarre to take DNA but not fingerprints for something. So this would be to add fingerprinting to the list of crimes for which you take, trespassing to the list of crimes for which you take fingerprints for misdemeanor if someone's convicted. Does it add to sort of the context as well?
Yes.
Okay. Everybody, so does anybody have any questions for the patrons on House Bill 1266?
Mr. Chair,
Delegate Mullins.
just a question for staff. At this point, are there any misdemeanors left that we're not taking fingerprints for? This is it? Okay.
Good. And actually, it's not a list, it's a, except you take them less, and this would be a less.
Any misdemeanor.
Okay. Right. Okay, this good law and order tough on crime bill. There's no cameras running, you're fine. All right, House Bill 1266 is before us. Anybody have any questions for the
No cameras.
That's right.
We're running.
No.
She's just taking me. I'm not taking you, she's taking me.
I looked in the camera when I said that, so. Any other questions, any other comments? All right, the bill's before us on a motion to report, and it's not referred, this goes straight to the floor, is that right?
No, I think this has a budget. No, we didn't. No, okay, that's right, we cleared that up. This goes right to the floor.
Okay. We ready? Let's cast our vote. Test your vote in electronic vote. It's like old times. All right.
It's pushed.
The clerk will.
Thank you very much.
Thank you, Delegate Toscano. Thank you. Okay. Amendment back. Okay. All right, everybody, it's 3 o'clock. The chairman of the subcommittee's got to run. He's got another committee to take. We've already asked, if nobody's walked in who drove 300 miles to be here and testify today, is that right? Okay. All the bills in the docket, well, we'll see you then. See you next time. Thank you. I was going to say, maybe on Monday, but it's not Monday. We'll see you.